have everyone in person. So I want to welcome you to CCSI's 16th annual speaker series. My name is Brooke Gouven. I am a senior legal researcher with the Columbia Center. This year, our series, as in previous years, is kindly sponsored by Arnold & Porter. And today's talk on the African Continental Free Trade Agreement will be the first of 3 discussions that we have this year. This year, each of our discussions is going to feature several discussants to explore important and timely policy-related issues at the forefront of investment law and policy. And after today, our next discussion in the series will be investment facilitation, a critical stock taking, which we'll have on November 16th at 9 a.m. Eastern. So you can find more information about that panel discussion and register for it on our website. And then the final discussion in our 3-part series will be on investment law and human rights. That will be the first week in December, but the date is still being finalized. So I'm going to turn the floor now to Kabir Dugal, Senior International Arbitration Advisor with Arnold & Porter, to introduce today's discussants.
Thank you very much, Brooke. Let me just begin by commending CCSI on the wonderful work that it has always done, thinking about law and policy, and for putting together an amazing panel of speakers. This is a real treat. This is how we like to start our speaker series, with a bang. Each of our speakers that we have are legends. We will be here for the entire hour if we have to do justice to their profiles. So we are not going to do that. I'm just going to give you a one-line summary, but Google them. I'm going to introduce them in the order of their last names. That's how we're going to do it. So with that, we have Professor Olabisi Akinkube, the Viscount Bennett Professor of Law and Assistant Professor at Dalhousie University. We have Dr. Africa Kiza, PhD Fellow in International Trade and Investment at Hamburg University. We have Roslyn Njengo, Senior Investment Expert, AfCFTA Secretariat. We have these fantastic speakers who have lived the topic that we are going to talk about, the African Continental Free Trade Investment Protocol, new thinking on investment governance. Very exciting. Brooke, let me pass it over to you to lead our discussion.
Thanks, Kabir. Definitely very exciting panelists who indeed have been living and breathing this, this process and this agreement in many ways. So it'll be a good discussion, to be sure. Kabir and I are going to start off the discussion today by each posing a few questions, and we'd very much welcome audience questions, which you can either put in the Q&A or in the chat. We'd love to get to those. We hope it can be interactive. We hope we can address the things that people who are attending are interested in hearing about. So please do that, and we will definitely get to those questions as well. So I'm going to kick off with a first question to Roslyn. So Roslyn, you have literally been living and breathing this, as Kabir said, and given your role as the senior investment expert within the AfCFTA Secretariat, and you're focused on the investment protocol, working on this day in, day out, I'd love if you could give us a lay of the land. Where does it sit within the context of the larger free trade area, which I believe is the second largest in the world behind the WTO? Where is this protocol sitting within that framework? What is the status of it, and what are the next steps that you're working on right now?
Thank you very much, Brooke. And first and foremost, allow me to thank the CCSI for inviting the AfCFTA Secretariat to this highly important speaker series. It is always a pleasure for us to participate in these events, to share our thoughts around the AfCFTA agreement itself and our hopes and what we anticipate to see in the investment protocol. As I always tell you, Brooke, and a few colleagues, as I speak, what I say is still under caveat in the sense that these are negotiations that are yet to begin in a robust way, and therefore these are conversations that are being had internally and also with state parties and member states as they are thinking through what they would want to see in a protocol. So take this not, like firm, that these are the things that are firmed up, but these are the things that the Secretariat, deducing from the discussions of the state parties, would hope to see in the protocol. So the negotiations of the Africa Continental Free Trade Area were officially launched on the 15th of June 2015. That background is important for some of us who don't have this background. It was during the 18th ordinary session of the Assembly of the Heads of State, a decision was made to establish the Africa Continental Free Trade Area. 3 years later, the AfCFTA Agreement was signed in Kigali on the 21st of March 2018, and it entered into force a year later on 30th of May 2019. Trade in goods and trade in services were negotiated under phase 1 of the AfCFTA negotiations, and phase 2 will cover investment, intellectual property rights, and competition policy. And 2 other protocols have now been added into the protocols on AfCFTA. This is the digital trade and the women and youth in trade. All these protocols are actually interrelated. They are all interrelated, and they are all aimed to push the AfCFTA Agreement's implementation to actually have an economic continent with empowered populace. Phase 1 negotiations culminated into the conclusion of the agreement establishing the AfCFTA, and the protocol in trade in goods, protocol on trade in services, and protocol on rules and procedures on the settlement of disputes. So those protocols were already agreed and negotiated. And I mentioned these protocols because, for instance, the protocol on rules and procedures on the settlement of disputes will have a strong impact on how we negotiate the issues around settlement of investment disputes. To date, the AfCFTA agreement has been signed by 54 of the 55 Africa Union member states. 1 country is yet to sign the agreement, and 41 of these countries have deposited their instruments of ratification of the AfCFTA. So you see, we are more than half. We are left with just a few countries, probably 13 countries, to fully roll out the AfCFTA in the continent. Work towards the development of the protocol on investment has commenced. And in line with the directive of the extraordinary session of the Assembly of the Heads of State and Government of the African Union, which was held in South Africa in December of 2020, it was agreed that the negotiations on the protocol on investment should be finalized by this year, 31st December 2021. So we are working very hard to see where this will go. We of course realize that we may not be able to finalize the negotiations, considering where we are at these negotiations. The Committee on Investment was established by the Council of Ministers this year, and the committee has since developed and adopted their terms of reference, which was a huge step. And most importantly, it has developed and adopted its negotiating modalities and guiding principles for the negotiation of the protocol on investment. The negotiating modalities and the principles, most importantly, are the ones that will then guide us on what areas to focus on while we are negotiating the protocol. In order to adequately support the state parties for the negotiations, the Secretariat has facilitated capacity building engagements, regional stakeholder engagements. These are to receive views on the potential issues for inclusion in the protocol. And at this point, we actually want to thank CCSI and other African experts who have actually supported us, particularly in the capacity building engagements and the stakeholder engagements to prepare or to build the capacity of the negotiators in the area of investment treaties. Preliminary work on the protocol has also been done, and discussions have been held with the Committee on Investment to identify the key elements and possible focus areas for negotiations in line with the state needs, while building on the initiatives and developments in the state parties, continental and regional economic communities. The implementation of the AfCFTA and the investment protocol could actually open ample opportunities for investment in productive capacities and in sustainable development, especially true in an age of mega regional investment agreements. To conclude on this section, the protocol ensures that African countries can also bank on the benefits of regional and international investment rulemaking, and the protocol on investment could aid economic recovery, especially if governments promote regional production networks and the development of regional value chains, as well as attracting market-seeking investments that will benefit from extended regional and continental markets. So all these will then build on what we want to see in the protocol. Thank you very much, Brooke.
Fantastic, Rosalind. I'm going to still stay with you for a moment before we move on to our other amazing speakers. But we are seeing some very novel, innovative thinking coming out of Africa. And you know, our topic for today is new thinking on investment governance. And that's what we'd like to talk to you a little bit about. Can you give us a sense of how member states in Africa are approaching this protocol on investment? What are the objectives, the principles? And perhaps to the extent you can do so, tell us how this differs from some of the other approaches to investment treaties. I know there was a lot there, but I know this is something you have been thinking a lot about, so we'd love to hear your thoughts.
Thank you, Kabir. Thank you very much. I was actually mentioning Brooke a lot because she was the one on the screen, so I kept seeing Brooke and not seeing Kabir. So the protocol is being negotiated with the broad objectives of the Africa Union Agenda 2063. And this is to transform African economies and increase intra-Africa trade through boosting productive investment within the continent. There's a lot packed right in there, quite a lot. So to unpack that, the Secretariat's clear objective is to ensure that the protocol must have provisions that work for Africa. So the discussions right now is that, listen, we are doing the protocol for Africa and for Africans. So we have to look at what is working. What is a challenge that we are trying to address? Where are the gaps in what is existing? And therefore, what do we want to have in the protocol? As you may know, the African continent is a hub of investment governance innovation on substantive issues. And the AfCFTA Protocol presents a very key opportunity for the continent to innovate once more in respect of important procedural issues, even including the investment dispute settlement, where Africa indeed will provide a unique voice. So the discussions are pointing to a protocol that will establish a modern and coherent continent-wide legal framework for three things: the promotion, the facilitation, and the protection of intra-Africa investments, while safeguarding the regulatory space of states. So the protocol on investment under the AfCFTA is expected to build on the initiatives and developments in the state parties and the Africa regional economic communities. Therefore, discussions have explored various innovative provisions in Africa that are aimed at rebalancing investment treaties away from the pure investment protection and towards sustainable development. Now, this is including the following, and you will need to stop me, Kabir, because now I go into where, you know, the real stuff is, and this is my passion. We have the following: treaties, growing integration of reference to sustainable development, for instance. So that is the first focus that the discussions are looking at. So the first one is the growing reference to sustainable development. So we have seen this in the preamble, we see this in the Pan-African Investment Code, We see this in SADC model, BIT. We see this in the EAC model, COMESA, and the ECOWIC. The provisions also under this, it's also the provision setting out instruments objectives. These are seen in the Pan-African Investment Code and the SADC model. The second one is streamlining of standards of protection owned by states to investors and ensuring that they apply to a narrower, more carefully defined set of investors and investments, for instance, through the following: either an enterprise-based approach to the definition of investment, which we are also seeing in the development of the Pan-African Investment Code, SADC, and the CCSI. You will notice that I mention a lot the models that are in Africa, because these are the ones that are actually setting the base for the negotiations. The third one, rationalizing the concept of key investment protection standards provided to investors. For instance, through drafting of non-discrimination provisions, as we see in new languages, excluding maybe national treatment or MFN in the pre-establishment phase, as we see in EAC model, among others. The third element, or is it the fourth? Development of new treaty language that is aimed at balancing the rights and obligations of states and investors. For instance, through the following: reaffirming the state sovereign right to regulate. We see this in SADC, EAC, Morocco, Nigeria, BIT. We see these in new language that imposes obligations on investors on issues such as corporate social responsibility. Again, we see these examples in ECOWAS, Pan-African Investment Code, and ECOWIC, including the COMESA Common Investment Area. Coming to the point of the objectives that have been agreed by the Committee on Investments to be the objectives of the Protocol on Investment, these are the following. They've been identified to include: to promote social and economic transformation for inclusive growth and sustainable development in line with Agenda 2063, to promote, facilitate, and stimulate intra-Africa investment flows through better harmonization and coordination of investment regimes and instruments across RECs and across Africa in general, to strengthen the regional markets, create wealth in Africa, and enhance competitiveness through increased production, trade, and investment flows in African countries, to promote within state parties an environment conducive to the development of a more vibrant and dynamic private sector that facilitates job creation, promotes technology transfer, supports long-term economic growth, and contributes effectively to the fight against poverty, to enhance African position in attracting FDIs, making use of the liberalization of trade in the continent that unlocks the huge market potential, and to resolve the challenges of multiple and overlapping memberships. And finally, on the objectives, to promote compliance by investors with domestic and international laws and norms. I don't know if I still have time to talk about the principles a little bit, but I can come back to that later.
Yeah, Rosalind, that sounds amazing. So much innovation coming out of Africa. I can't imagine how these discussions are going amongst all of the member states, because they're really thinking deeply through a lot of these issues. BC, I want to turn to you to maybe draw that out a bit to the global level. Your work, you do a lot of thinking and guiding on these topics. Can you maybe comment about how you see the investment protocol fitting into this global picture of where investment governance is headed? Because it really is at a inflection point in how we think about governing cross-border investment. I'd love your thoughts.
Okay, so thank you very much, Brooke, and nice to see Kabir and Nancy and all involved in the planning of the event. Equally nice to sit with Rosalind and Africa on this panel. So I think that we need to situate the negotiation of the AfCFTA Investment Protocol in the complex mix of international investment governance generally. And by that, I speak not only to the governance regime, layers of governance regime at the international level, but also, as Rosalind mentioned, at the continental and sub-regional continental, regional, or sub-regional level. And indeed claims these days that we see for devolution of disputes to the national courts, arguments that we're seeing, to which I'll get to. But, you know, to be more specific, I think we have to realize that African states are at crossroads with respect to what they want in relation to international investment regimes. There was an opportunity codified in the Pan-African Investment Code, which I've written about, which many people, Juan Kidane, McCann, Bengwe, Vironke Odumosu, others have written about to several degrees of the whether you agree with them or not. On the one hand, window dressing changes that it's made, or as some have argued, very substantive. And I believe that it is somewhere in between that, and that's not bad with respect to the sustainable development goals it has set. But structurally speaking, the UNCITRAL Working Group 3 reforms are going on. That is largely procedural. A lot of questions have been asked about its substantive capacity to address the structural concerns of international investment regime. So we have that on the one hand. On the other hand is the big ISDS regime, which has seen dissidents, not just amongst African states, but also amongst developed countries. I mean, we do see what is in the context of the USMCA, Canada's position in relation to ISDS. So certainly for various reasons, various parts of the world continue to express concerns with the ISDS regime. But then we have the regional context, as Rosalind has so rightly said, in the context of the sub-regional courts and the regimes of investment agreements that exist out there, which the biggest challenge remains the extent to which they are implemented or useful for the purpose of addressing BIT obligations that have roots in private law and property law context in investment regime. So all this is to say that while the negotiation of the AfCFTA Investment Protocol, when it is eventually concluded, will sit at the top of the list of dispute settlement mechanisms potential in relation to investment on the African continent, it comes right under the many other ones that are existing out there at the international level. And African states do really have a challenge of how to deal with this complex matrix of dispute settlement regimes, which on the one hand may easily facilitate forum selection, you know, lead to disputes being taken up in various areas. And as Rosalind has said, if there's continued, which I think will be, protection of national policy space for these countries, then you do wonder what level of obligation might arise from the AfCFTA Investment Protocol. The understanding, as we've seen in papers that we've read so far, is that this is not going to be a regime that will harmonize or, you know, create this coherence, at least not from day one when it is concluded, even if it aspires to do that. So that's where it is. It adds to the complex regime, spaghetti bowl, if you like, of international investment dispute settlement regimes. If the multilateral investment court sees its own day, then you might ask what it means for this. But again, it doesn't stop the continent from aspiring. And it is about what it aspires to do. And I think Rosalind has so well pointed out some of those concerns. I'll stop for now.
Thank you, Professor. I think we probably saw a little bit in your response, but maybe we hone in a little deeper, right? Perhaps you can tell us about the investment protocol in the African context specifically, right? We're talking about probably a region that is very significant, but also very innovative. What is the potential here? You know, we're seeing African states lead bilateral, regional negotiations for policies and agreements. What is the potential for intra-African investment? What can this model mean globally? And you touched upon this, how are you looking at the future of ISDS if you had a magical ball to predict the future? A lot in there again, Professor. Whatever you would like to share your insights, we'll be grateful.
No, thanks, Kabir. I think it's I think there's a lot in there, as you've said, but maybe rather than bother too much about the ISDS future regime, I don't have a crystal ball about how it will go. If you ask me, I think we may still be having this type of conversation almost a decade from now. Is my own thinking because of the private law regimes in which they are settled. I think they'll get more complex with the issues of climate change and environmental justice. The Echo dispute shows us a little bit about how that might be. The capacity of international investment agreements to deal with critical issues, of sustainable development, environmental justice, climate justice, socioeconomic rights are difficult. And I don't know that it is to be left to arbitrators to really guide, where this will be. But to come back to the other interesting point that your questions raised is in relation to the intra-African dimension. I'm not the only person who's made this argument, but I think there's a case here. I mean, some call these rule makers, I've called it Africanization in some sense, but there's a case here for non-generation from the African continent, and we shouldn't miss that opportunity. So it's about how bold member states are willing to be. And I think it's high time we do not see ourselves caught short from this process that is ongoing. Procedural justice issues are important in my view. And I think African states, to the extent that we cannot disengage from the international realm, have to engage with the UNCITRAL working group despite its deficiencies. I think that's starting point one. Starting point two is a bottom-up approach. And this is where the intra-African, innovations come into the realm, right, of how we might think about how these issues center our own concerns. We won't address them first at the international level. I just think it is too much for the African states despite their capacity to do. So I don't know if that goes too specific. We can look at context of agreements in the regions. We can look at states' actions, Tanzania, South Africa, Nigeria doing different things. Even the Nigeria-Morocco agreement, for example, that's been praised for its innovation and so on and so forth, hasn't taken off, right? So there's so many granular issues you can look at than sometimes, statements, preambles, non-obligatory provisions that really do not drive home the point, which at the end of the day may actually cause more damage for these communities. So yes, I think there's opportunity for the continent to define its own agenda through this agreement. I think such an agenda can be improved by strategic engagement with negotiations that are going on in the UNCITRAL working group. It's not perfect. I don't know, my view, that a substantive reorganization of the entire regime of the International Investment Agreement can be done at a go. And as I've argued in my own work, maybe incremental steps is what we have to take. And if that becomes, that what we do internationally while at the regional level, being bold and serious about these processes, then we may actually start getting to those places that as a continent we want to be, which is really people-centered regimes for the protection of investment relations. Thanks.
Thanks, Bizi. Really, yeah, I'd love to turn to Africa now. Africa, you have spent quite a bit of time, even though you're wearing your academic hat today, you have spent quite a bit of time working in and with civil society in in this context, working on investment issues, helping to guide civil society thinking, and you're quite a leader in that front. So can you talk a little bit about what the role has been and maybe what you envision the role should be for civil society in this process as this protocol is developed?
Well, thank you so much, Brooke and Kabir. Once again, it's a pleasure to share this forum with a distinguished panel and diverse audience. To understand the role of civil society in these negotiations, we need first to go back and examine the negotiating dimensions of the CFTA and how it was built, the framework. You see, the CFTA, when Lozrin was given the task, it was a defined task. The CFTA Secretariat and the African Union were supposed to generate positions from the existing national consultations and regional economic blocs. So the CFTA Secretariat, or by that time, before 2020, the AU division of the CFTA division of the AU, we are supposed to rely on discussions and consultations that were undertaken and research that was undertaken by at the national, respective national level by the AU member states. Now, it is important to understand to what extent this went. Over and over since the inception of the CFTA negotiations, there has been what I may wish to call an exclusive approach of the negotiations, and the involvement of civil society has been rather limited. Yes, at CITIN we have had the privilege of engaging, but it has also been upon approach. But the framework of this negotiating principles an inclusive consultative approach, where they would consult civil society, consult private sector, and all that. Now, again, when you look at how we have fared, there have been inconsistencies in what is said and what is done. An example is we are yet to negotiate the investment protocol, but we have already countries like Kenya and Ghana, which are concluding free trade agreements with investment provisions with third parties like the United States, like the UK, and for example, the case of Kenya with the United States. So this brings an approach of preference erosion. We find that by the time we negotiate the investment protocol, the FTA, then we have less to get as Africans. And most importantly, again, you see the context of the investment landscape in Africa is diverse. We have countries like Mauritius, which are acting as tax havens, which are acting as conduits for FDIs, which are most likely to place themselves to benefit from the investment program. So the issue has been that to understand the involvement of civil society, we have to first examine those deficiencies. And the role of civil society should have been to ensure that we create checks and balances, because at the onset, the CFTA has been based on timelines. Let us meet, and these are political timelines that the AU heads of African Union heads of state meet and decide that by December 2020, we should have the CFTA negotiations finalized. And that creates kind of a risk that focus will only be on meeting the timelines with less consultations, or with a hypothesis that, with a thinking that member states have duly consulted their constituencies, including civil society, which sometimes has not been the case. So civil society comes in to provide research, to bring about to mention such underlying challenges, which can be imminent, and in terms of impairing the would-be benefits from the CFTA. And what would have been the most important role of civil society, again, is to ensure that we have a collective voice and agency of non-state actors influencing the outcomes of the CFTA investment discussions protocol. So that is the kind of role that civil society should have played, which it really has not duly played. An example is, for example, if you look at the CFTA protocol on women and trade, women and youth in trade, you see the women movements are celebrating, and you ask them, what is in there? They don't know. They do not understand that the way we negotiate tariffs is also going to support them. We do not understand that the way we negotiate services liberalization is going to affect on how we utilize the benefits of the CFTA investment protocol. So the kind of role that civil society plays is to also create such linkages that negotiators often do not look at when they are using the text-based negotiation and consultations. Thank you.
Thank you, Africa. To our audiences, we invite you to keep putting your questions in the chat. We will be opening the Q&A very soon. But before that, Africa, what kind of outcome do you foresee from the investment protocol negotiations? And what should the protocol and investment look like to benefit people and the planet and Africa, the continent, more generally? Please, Africa, I know there's again a lot there.
Yeah, thank you, Kabir. Of course, a people-based, CFTA is really very important. And when you look at Africa's investment drivers, really, Africa has been attracting most of resource-based investments. Those that are looking at minerals, that are looking at other natural resources, and this is a bit rather problematic because again, so you find that we have very liberal investment regimes, and the CFTA again risks making this even more deeper, because whether we are liberalizing as intra-Africa investments or whether we are liberalizing with other third parties, the effects of liberalization are the same. So a CFTA investment agreement protocol and agreement that balances like Rosen put it, that balances the rights of the state, but most importantly, the communities, because in many instances in Africa, it has been commonplace to see states actively participating in violation of the rights of the citizens and communities in order to pave way for investment, for FDIs. We have seen states, for example, participating in displacements of communities. We have seen states engaging in what we call the race to the bottom by granting, a lot of tax holidays and exemptions to FDIs or to investments at the expense of the taxpayer and at the expense of domestic investments. So whereas the CFTA protocol on investment is going to now bring about investments which are domestic, it is important to ensure that the rights of communities and most important also the environment are adhered to, because again, in many instances, especially in least developed countries of Africa, we have seen states again giving exceptions and I may say foregoing environmental impact assessments pre and post establishment for the sake of attracting investments. Now, the most important thing I also think I would want to put across is the question of movement of persons and the way it is going to be synchronized with investment regimes. Because again, at the onset of Kigali in 2018, when we signed the CFTA, many countries, for example, rushed to sign the declaration of the CFTA, but few countries signed, for example, the protocol on movement of persons. There was at the onset cherry picking on what should be the building and supportive annexes to the CFTA function. So again, addressing that aspect, more the four categories, for example, harmonizing mutual recognition of certificates and agreements, and most importantly, ensuring that FDIs adhere to performance requirements, especially not FDIs, but rather investments, intra-Africa investments adhere to performance requirements, but also local content and technology transfer. These are important. Otherwise, we might have we risk having an intra-Africa investments, which are also, again, more damaging than investments with third parties. Thank you.
Thank you very much to all of you. So as Kabir said, I want to get to some of these questions that are coming in. Maybe I'll highlight one or two of them and give you each maybe a minute to respond if you want. I'm going to combine two questions. One is from, and apologies if I get the name incorrect, Justice Osie Afriye and Shibusiso Gama. So both of you have touched on this question of kind of sustainability, tangible effects. How can we ensure that the investment protocol is actually evolving and is actually going to put into place the necessary systems, processes, substantive protections or obligations that are necessary to achieve these broader objectives that we see this week being discussed at COP last week and this week, the Sustainable Development Agenda, not to mention, the continent-specific development agendas. So maybe you could each comment a bit on that question. We'll start with Rosalind.
Thank you. I think I'll say something very brief around this because one, the protocol is yet to be drafted, right? So what we were doing is picking out from discussions what would go into the development of the protocol. And one of the areas is sustainable development. Now, it is important from our conversation, it is important for the protocol to reflect issues of consistency between the state parties' economic and non-economic goals and articulate the need for the balance between a state's development objectives, sustainable development objectives, and the protection of investors and their interests. So it is actually intended that we clarify the intent that the sustainability we are talking about is the holistic approach of what we want investment to be. What do we want investment in the continent to have? We want the investment that we have, both intra-Africa investment and inter-Africa investment. We needed to have the sustainable development elements of ensuring that we get proper jobs, we get quality investments, we get economic development in the diversity that is required within the communities or within the environment of the investment. So that is what we want to see in the protocol. So it touches on quite a number of things, but maintaining that thread of sustainability. I don't know. I know I've danced around the issue, but I hope I've addressed it a bit.
Thanks, Rosalind. BC, did you have any thoughts to add?
Thanks, Brooke and Rosalind. So I think that this is the challenge that we face as a continent that I referred to, that one hopes that the AfCFTA negotiators of the AfCFTA investment protocol will be bold. Because the national economic policies, economic development policies of African states differ. Their relationships to investment regimes, as you know, has become evident in this conversation, differ. So the idea is that the AfCFTA investment protocol, when it's negotiated, will mimic something that calls for, at least in an obligatory sense, for sustainable development along particular lines. Looks to me far-fetched. I don't know that it is an easy thing to do if we want the states to really back this. I think what it proposes to do with the language of AfCFTA Protocol on Trade and Goods and Services is to call for a cooperative regime, right? And if what it is calling for is a cooperative regime amongst the states, then it continues to cede the national space. And that means within the national context, whether in the negotiation of BITs and other types of IIAs, primary issues that are of relevance today, climate justice concerned, environmental protection, clear definition of what investment is, fair and equitable treaty provisions clearly drafted with concerns of the states at heart, are the kind of things, amongst many others, that has to be done. And yes, we don't have to buy into ISDS. So if there's a language that starts to discourage that and support some of the member states that are already pushing against this, easily called dissidents when it is African states, except when Canada is doing it right, it looks like the norm to throw their power around. So I think that, the content of sustainable development we see in Agenda 2063, as Rosalina said, in other types of documents that are very aspirational, but the accountability that comes with them at the national level means that one hopes again African states in their negotiation of this agreement will think about ways in which they empower, whether at the sub-regional, more particularly at the national levels, arms of government that will be important in doing these jobs. And I say this not being aloof of the fact that it's not an easy process. We have so many socioeconomic and political factors that makes, devolving such powers to the national level much more complex than one wants it to be. But we have to start somewhere. And if this protocol is the basis for that, then I think it has to be very clear about its own objectives, even if it is aspirational in that regard. This is only to one aspect of the question on this issue of sustainable development. I guess we'll come back on the others.
Yeah, we can come back on the others. Africa, did you have thoughts that you want to add on this this particular question? Oh, perhaps Africa's connection has frozen, in which case, Africa, I would invite you to stop your video if you're still on, maybe that will help. But perhaps in the meantime, we could move on. Kabir, did you want to highlight another question that's been asked?
Yeah.
Oh, Africa, are you still with us?
Yes, can you hear me?
Yeah, it's a bit rough of a connection, but go ahead and try and I'll let you know if not.
Oh, well, I think one critical issue that needs to be recognized is the different levels of development, like Labisi put it. In the CFTA negotiations, Rosen maybe might clarify, we had a special group of countries, I think it's the G6 or G8. This is not the traditional G8 of the US and Iraq. It is a group of African countries which have special challenges or special requirements on what kind of levels and what kind of offers or preference they can give. And so countries like Sudan, countries like Zimbabwe, these have special challenges and special statuses that we need to put into consideration when we are designing the issue of sustainability. And again, countries that have aspects of, for example, services based investments are different from countries that are largely attracting investments on natural resource based. So there are different approaches that we need to use when we are designing different interventions and aspects of the investment and sustainability component. Thank you.
Thanks, Africa. I'm going to turn to, there's a few questions related to Africanization of the regime, which we might get to in a minute if we have time at the end, because those are also quite interesting. I do see there's a few questions relating to the ISDS mechanism. So I just want to cut to the chase and ask this question. Are we going to see ISDS? Is it possible we're not going to see ISDS? And given, maybe if you want to elaborate, but there's this question of existing intra-African agreements that already have ISDS. What's going to happen with those? Rosalind, if I could turn the floor to you first again.
That is a very tough question. Indeed, it's tough in two instances. One, we are yet to get to that point of negotiation. So for sure, I cannot say anything about it. What I know is what exists at the moment in the AfCFTA agreement itself is the state-to-state dispute settlement mechanism. Now, we don't know whether the state parties will find that sufficient, or because of the complexities of investment, they might want to have other available options. We really cannot tell. So that one is an open question, that's as open as it is to you and to me. The other one was on
It was related to termination of intra-African.
Termination. Again, that's a question that is up in the air because these are state obligations. These are what's the treaty as we envisage. We would not want to affect the sovereignty of a country. But at the same time, you would want to say, okay, so if we have a protocol that is signed by the Africa Union member states, and then you have another bilateral protocol between country X and country Y in Africa, how will those two interrelate? So there may be conversations, and these conversations have actually come up during the expert group meetings, that we may need to consider termination of existing treaties, intra-Africa treaties. But again, caveat, these are conversations that are yet to be translated into negotiation. So while we are negotiating, we will then need to know the relationship between the investment protocol and other treaties that are existing. I'm sorry I'm not able to answer much because you see, these are dynamics of negotiations.
We all want to be a fly on the wall, Rosalind. I'm going to actually have Kabir direct another question now.
Sure, thank you. Let me direct this question to Bessie. Bessie, you spoke about Africanization, right? This was a term that you had used, and it's a term that has invoked a lot of reactions from our audiences. They're keen to understand, what would this Africanization entail? How would that work? What sets this protocol different from what we are seeing around? What is truly uniquely African about it? All kinds of reactions and comments. So let me just throw that to you. What and how do you see this Africanization in relation to the protocol taking effect? What's the vision and what's unique about it?
Okay, so thanks a lot, Kabir, and thanks to the participants who've asked the question. I've written about this in the context of international investment law, and maybe I should share that the motivation for writing initially was to question what I consider as an uncritical use of the term Africanization. It does seem, when we talk about Africanization, people think, it's about just doing something which, once we interrogate, we don't know that is African, right? So the beginning is this. It is a concept, right? And it is a concept that is subjected to different types of interpretation. And so one can put Africanization on this side and put Pan-Africanism on this side, right? And try to bring them together and ask this interesting question. Do you think there's anything homogeneous about what African states want? Can there even be within African states themselves divisions, fueled by national sovereign interests, which means that, as we're seeing in the context of Ghana, Kenya, for example, there's a problem, right, already happening in relation to cracks in there. So that's one level theoretically at which we need to interrogate such a term. That Africanization, as I've written about it, is an invitation to think of the various multifaceted contexts in which the continent exists, and that articulating a lot of what has happened at the sub-regional levels is actually germane to the future of the continent. As I've written about it in the context of the dispute settlement for the protocol in trade and goods and services, what I've said is, look, why do we have these sub-regional experiences? And I'm not the only person who've written about this, and we're looking at the WTO transplantation effectively. How did we pivot to that level, right? And what does it tell us about our experiences as a continent? So in the context of the negotiation of the investment protocol, what I hope for is that the negotiators will really seize the opportunity, and as Rosalind is saying, the guiding principles, the consultations, to really put on the table what African states want. And I think the idea that there has to be a voice of the African states is maybe a thing that we haven't really given enough consents to, that's probably not so easy to do. And that's why I think the AfCFTA took the approach it took, cooperative, member state driven. It's not supranational. It's not going to tell member states what to do, but it hopes that they carry this on. And so whether it's in the context of putting at the heart of their negotiations socioeconomic rights of the people, of the communities in which the investments will be situated, right? Environmental concerns, climate justice concerns. These things are not going to go away, but they're not also going to be solved with one silver bullet. And so how we gradually start negotiating them, and this is where Africanization, as I've argued it, called for a moderate understanding. At one end of it is a spectrum for radical change. I think that is utopian, if you ask me. I think we may just end up in the NIAO of the 1970s and how it failed if we go too far with that. And in the interim, a lot of the very many inequalities that we've written and are concerned about continue to go on. So we have to find a middle ground where we continue to make the move and calls for these changes, but acknowledging that within the context within which we're working, such issues as procedural justice concerns are addressed, right? So at least address the concerns we have in relation to BITs, IIAs, and all other types of agreements that we've settled and for which there are settlements going on. So I can speak more to these, but I don't want to monopolize the conversation once I get excited about it. Thanks.
We like excitement around here, BC. In the last 3 minutes, so I really want to turn to each of you maybe for any concluding remarks, but also I'm going to throw out this question to follow up on what BC has articulated, in that this is an intra-African agreement. We still have the norms, the rules, the treaties with extra African countries. So what is there going to be guidance on that? Is there going to be, how are we looking at this agreement in that broader context? So either that or concluding remarks. It looks like we've lost Africa, so I'm going to turn to Rosalind and then BC and give you each 1 minute to respond to that. Thanks. Rosalind? BC, go ahead. Yep.
Okay, your question is how should we think about the future of this?
And also in the extra African context, right? We're talking about Africanization, intra-African context, but there's a bigger picture here.
Yeah. So this is the question. There's no not being at the table to start with in the external context, right? I love to distinguish these things. There's the academic debate, right? Which is about how do we think about a system, conceptually as academics, that would be good. But there's the practicality and reality of the system, that law firms continue to represent clients, that clients continue to have disputes, that these disputes continue to come out of existing and undergoing negotiation and revisions to existing trade agreements. And so African states, at the international level, must be involved in the procedural justice questions that are being addressed as the ISDS, at the UNCITRAL Working Group 3. We don't like everything they're doing, but it's not a case to throw out everything at that level. And as much as people make distinction between intra-African investments, I question why, right? Is African capitalism, if there's such a thing, different from the capitalism that exists anywhere else in the world, right? And so aren't they the same actors at the end of the day? Don't they have investors from every part of the world? So we need to take a holistic account of the issues and not necessarily separate them. And hopefully, as you know, the hard work that Rosalind and others are doing continue to go on. Their paths are illuminated by ideas, by scholars. I'll post one from James Bethy, one Kidane, Bironkel Dumosu, and many other people who write about these things. But that's it for me. Thank you.
Thanks. Some of those people are joining us today, actually. Rosalind, final words.
Thank you very much. And here I'm going to be ambitious. And I will say, first of all, when we are developing laws in the continent, we were discussing the other day, why do we call them regional? And when the laws come from another area, we call them international. So the ambition with us here is, in terms of our relationship or the relationship of the protocol with what is going on internationally, we take cognizance of the fact that investors will invest where they feel comfortable. Investors will invest where there is a return on investment, and investors will want circumstances where their resources are catered for. But the states will also want a return on that investment on economical and social perspective. But so what we want the protocol to do and how this will touch internationally is that the protocol is Africa-owned, Africa-led milestone in international investment law. And we envisage that we want a historic treaty for standard setting, dispute prevention and resolution, and a treaty that imbues transparency, predictability, and legal security for both investors and the African states, while being rooted on the imperative notion of sustainable development.
Thank you. And Africa, I see you were able to rejoin. I don't know if you heard the question.
Yes. No, I didn't. Yeah, I had a question. My parting shots.
Okay, great.
Yes, two things. One is the issue of coherence is very paramount, especially coherence in terms of what are the aspirations of the investment protocol and what is actually the talk, and what is actually the actions. Because the actions tend to be divergent, tend to differ from what the aspirations are. Like Rabisa had put it earlier, we are looking at facilitating and creating more investment preferences, more opportunities for intra-African investors. But here again, we are having countries going bilaterally. And the issue of preference erosion, like I had put earlier, is an imminent risk that we are likely to see if we do not, put a halt on negotiating individual bilateral investment treaties before consolidating our positions in the CFTA investment protocol. The last point is the issue of understanding the challenges of investment in Africa. Quite often, because again, whether we have intra-Africa investments or inter-Africa investments, the challenges do not change. Challenges of human rights violations, challenges of environmental violations, challenges of rent-seeking investments do not change. And most importantly, challenges of technology transfer, which are often lacked. I think these are very critical issues that we need to look into. And of course, since I've been from the civil society, it is important to ensure democratic negotiations, not only in the CFTA investment protocol, but also other subsequent, protocols and annexes. Thank you so much.
Thank you very much. And an hour is clearly not enough time to discuss the everything that we could discuss about this really innovative. And I'm sure once we all see it, terrific text and agreement that's probably going to be coming out. So thanks to everyone for joining us. Thanks to all of our panelists. Thanks to ANP for their support. Really rich discussion. And again, this is the first in our three-part speaker series this year, the next of which is going to be November 16th on investment facilitation. So thanks again to everyone for your time, your efforts, your insights, loved it. And we will see everyone at our next speaker series event. Have a great day and evening. Bye.
Thanks a lot. Have a great day and evening. Bye.
Thank you. Have a great evening. Good night from Kampala.
Thank you. Thank you very much. And it was a pleasure. Have a good evening, have a good day.